the nadir period was a period in which really nothing positive was happening, right? And people sort of don't even bother to study it because they figure there's nothing that is that interesting about the period before, say, the 1930s, when activism started to actually make some difference. Um, but I think there was a lot happening, and there were a lot of debates and a lot of sort of seeds sown that then needed to sprout and grow over a period, despite the fact, to continue this metaphor, that the soil was very hostile.
These civil rights activists were, working at a time when the Supreme Court was not very receptive to what they had to say. And, we may be going into an era where the Supreme Court is going to be quite conservative for perhaps decades to come. How did they adapt to those circumstances, and what lessons do they have for us today?
In the era that I look at, there was a lot of work that was done at the state level. All the forward-looking, all of the progressive legislation that occurred during that era was all in states where the conditions were appropriate, and some of that legislation ended up being very much sort of a template for things that could happen in other states, and then eventually at the national level when the political conditions were right. The other thing that people were doing at a national level, and I was able to really document this, I think, in the book, was there was a lot of defensive work going on. So the Afro-American Council had a very strong presence in Washington, D.C., and they had a number of their members and leaders were ensconced in different national civil service positions. And they were keeping an eye on things, and they were working really hard to prevent more damage than could have happened. And there were certainly a lot of initiatives during that period that would have been really, really damaging as matters of legislation, and including on issues like segregation, school desegregation, all kinds of things, voting rights. So they really worked hard to fight those initiatives back, and they generally succeeded. And then there's a lot of work, and the women's clubs, I think, were particularly active in this, that was in the so-called voluntary sector, in local communities, municipalities where nobody was going to provide like sanitation and policing and fire protection and hospitals and juvenile reform programs and all of these kinds of social services that were so important, that were, of course, the hallmark of the progressive era. None of that was being provided to African American communities at all. And it was really the women's clubs who said, well, let's get in there and we're just going to create this for ourselves. And of course, there are limits to how much they could do, but they certainly were the prototype and the example that inspired Jane Addams and all of her work. And if that had not existed, I think we would not have had the successes that occurred, starting in the 50s through the 70s. That all was built on this amazing sort of substructure of prior work.
On strategies, one of them that I thought was interesting that was listed was test litigation.
Yes.
Which I think a lot of us hear about in the 50s and 60s, but not before that. Right. So could you explain a little bit about what that test litigation strategy was?
Actually, when you go back and look at it, corporations were using test case litigation from the early 1800s. So it wasn't a brand new idea. And certainly there was test case litigation around school desegregation in Boston, Massachusetts in 1830. The purpose of using test case litigation in the era I'm writing about was never really to achieve huge gains. So of course, every time there was a gain, that was a good thing. And many times the litigation lost, but to generate public attention, to generate international attention, to shame the courts and the legal system for failing to live up to the principles of the Declaration of Independence and the Constitution. So there were lots of reasons for those strategies, and that was very well understood at a sophisticated level, even in these early years. So many scholars later criticized Brown v. Board of Education by arguing that it was a failure. There was too much backlash. People were naive. How could they possibly think that that case was going to solve all of the social problems of segregation? And the point is, the activists and the long collective memory of these activists never thought that. Nobody, except for law professors, a few law professors who remain nameless, really believed that test case litigation was the solution to these problems. It was just one of a number of strategies.